Talk Radio 105.9 KNRS. Listen and you'll know on this Wednesday afternoon. Last night, State Senator Dan McKay joined us on the show. Senator McKay says he will introduce a bill when Utah lawmakers begin meeting in January 28th, as a matter of fact, to do away with SB54. Senate Bill 54, as you recall, was a compromise between the Count My Vote people and members of the Republican Party to develop a dual-track system for candidates to get on the ballot. They could either go through the caucus convention system, which has been around in this state and I think worked very effectively for a long, long time, or they could go gather signatures to get their name on the ballot. But there have been rumblings out there that some lawmakers may want to do away with it. Let's talk more about it right now with Daniel Ortner. Daniel is opinion contributor at The Hill. He also works for the Pacific Legal Foundation. He writes about the importance of the caucus system. Daniel, how are you? And welcome to the show.
Hey, doing well. Thanks for having me on.
Let's talk about this caucus system. Why do you think it is so important, Daniel?
So when I was in law school at Brigham Young University in Utah, I was a precinct chair for the local precinct where I lived in Provo. And I had never had political experience before then at all. Never really had any real involvement. And I was just blown away by how the caucus and convention system created opportunities for especially young, politically active individuals to get involved with the political party, to gain grassroots experience. I became a precinct chair, and the following week I had my local reps, state house representatives and senators reaching out to me, wanting to meet with me to discuss issues that were important to me and to them. That was just, it blew me away. As a young 20-something law student, I was able to meet with those at the state house that were making decisions for the party and for the state of Utah. And that was just something that I could not imagine having that level of involvement and experience without the caucus and convention system.
Did you go into Daniel, did you go into this maybe a little ignorant, not sure what it involved and what we have to do? And did you come away going, man, this is great?
Yeah, I went to the precinct meeting sort of on a whim. I've always been politically interested and involved, but I went to the meeting not knowing, my first precinct meeting, not knowing what to expect at all. And then I was encouraged by a friend to run for precinct chair because he knew I was very politically engaged and interested, and I was a law student and really passionate about certain issues like religious freedom, individual liberty more generally. And so I was encouraged to run, but I had no idea what that entailed, and it really surprised me. How the system worked. It was a complete surprise to me.
Why is this system so good for the state of Utah and maybe other states, in your opinion, Daniel, compared to a direct primary or going and gathering signatures and get on the ballot? Why does the caucus convention system work the best?
Look, I think want to acknowledge any system has trade-offs. No system is a perfect system. The caucus system has strengths and it has weaknesses. The biggest strength, though, is that it allows for the development and engagement of individuals in the system to be part of the political system, to gain experience, to rub shoulders with legislators and lawmakers. I think that's one of the big benefits. I think the second benefit can best be shown by the election of Senator Mike Lee, who is, I think, one of the best senators in the country, who could not have been elected without the caucus and convention system, because an incumbent like Bob Bennett, who was well established, had the finances, it would be very difficult to defeat him in a primary race. From the convention system, you were able to appeal to those members of the party that are most politically engaged. You're able to appeal directly on the issues rather than who has the biggest war chest or is able to launch the most negative attack ad campaigns, negative ads. And so I think it allows for insurgent candidates who really care about the issues that the party represents to be able to upseat very well-established incumbents, because it reduces the barrier for entry. It reduces the cost, the amount of money one has to spend to win a political seat. And I think that you can't understate how important that is to allow a vibrant party where ideas are at the center of the party rather than who has the biggest war chest or the best fundraising network.
Now, I know, and you write about this, Daniel, that the Utah Republican Party is challenging this They were struck down by the 10th Circuit Court of Appeals, but they're now trying to get in front of the U.S. Supreme Court and the Pacific Legal Foundation, which you work for, along with the Cato Institute and the Freedom Partners Chamber of Commerce, have all joined on the side of the GOP. The argument has been that because the state runs elections, they can kind of tell parties how to do, how to run their own organizations. What do you make of that argument?
Yeah, so the Supreme Court has very clearly said that while states have a lot of leeway to regulate how elections operate, the means of an election, of the general election, they are limited in their ability to interfere with the internal decision-making of the political party. And in particular, most importantly, they cannot tell a party who is going to be their nominee, what kind of nominee they have to choose. The Supreme Court cases speak out of two sides of their mouth. And on the one hand, they very clearly establish that principle that parties have freedom of association rights. On the other hand, they have such language talking about how the state can ensure that the party is democratically accountable. Such language that I think is harmful ultimately to freedom of association. And that's why I hope that the Supreme Court takes this case because it's a particularly great opportunity to clarify that political parties do have freedom of association rights that are protected by the First Amendment, and that what Utah has done oversteps those bounds.
Yeah, and the court hasn't made that decision yet. Any guesses to which way they'll go on this one yet, as whether or not they even take up the case?
Sure. I think obviously the Supreme Court gets a lot of petitions asking it to take on cases, and very few of them are granted. But I think there's a decent chance here. Election law in particular is one area where usually the Supreme Court wants several courts of appeal to have different opinions, to have a circuit split on the issue of the case. But election law is one of those unique areas of law where the court will take the case even without a circuit split, because they recognize how important it is to protect freedom of association, freedom of speech, and also to ensure the operation of the electoral system. And so I think that there's a decent chance that the court will take it. I think it's helped by the fact that in the 10th Circuit, Judge Tinkovich wrote a very impassioned dissent, a very powerful dissent, making a lot of the free association arguments. And so I think the fact that you have a very persuasive, very powerful dissenting opinion will likely, hopefully, push the Supreme Court toward taking this case.
Well, we'll have to see what happens. We can only hope, Daniel. Daniel, thank you very much for your time. Hope to have you on the show again.
Yeah, I'm happy to be on. Thanks.
All right. On our Newsmaker line, Daniel Ortner. He is an opinion contributor at The Hill. He also works with the Pacific Legal Foundation, talking about the GOP appeal to the U.S. Supreme Court. No decision has been made yet as to whether or not the court will take this up, but it's all over SB54. More coming up on the Rod Arquette Show.